Good afternoon. I will immediately turn to the courtroom schedule for this week and next. The Rule 98 bis hearing in the trial of Vojislav Šešelj started on Monday afternoon with the oral submissions of the accused, which were followed by those of the prosecution yesterday. The hearing is expected to conclude this evening. The Chamber will announce in due course the date at which it will render its oral decision on whether to enter judgment of acquittal on any of the counts the accused has been charged with. The media will be informed of the date accordingly. On Thursday, a status conference will be held in the appeals case of Milan Lukic and Sredoje Lukic at 3 o'clock in courtroom 3. As to the ongoing cases, in the trial of Radovan Karadzic, the Chamber is currently hearing the testimony of the 69th prosecution witness, KDZ-182, a former UNPROFOR member who served in Sarajevo during the war. And in the trial of Zdravko Tolimir, witness Emma Sayer, former UNPROFOR liaison officer and interpreter, is currently testifying. She is the 91st witness to be called by the prosecution since the start of the trial in February 2010. The prosecution announced yesterday that it expects to conclude its case before the end of July this year. And to conclude, I would like to bring to your attention the latest activities of the Tribunal's outreach program and recent developments in the War Crimes Justice project. The outreach program yesterday welcomed a group of political science students from the University of Belgrade in Serbia. They attended presentations given by the staff of outreach and the Office of the Prosecutor and attended the Rule 98 bis hearing in the trial of Vojislav Šešelj. As part of the War Crimes Justice project last Friday, the Tribunal delivered 2,500 pages of transcripts produced in local languages to Bosnian and Croatian legal authorities. The provision of transcripts in Bosnian, Serbian and Croatian will improve the ability of local legal practitioners to access and utilize testimony given before the ICTY. Since the launch of the EU-funded project in September 2010, the Tribunal has delivered 7,000 pages of public transcripts to the authorities in Croatia, Serbia and Bosnia and Herzegovina. More transcripts are expected to be delivered in the region in the coming months. Over 4,000 pages of transcripts already produced as part of the project are now available on the Tribunal's Internet Court Record database. Office of the Prosecutor.
No statement, but I can say something on the, unless there's a question, I can say something on, to clarify for the record what's happened with Mr. Divjak and our role in this matter. Mr. Jovan Divjak was never indicted by the tribunal. There have been no judicial proceedings before the court. We can confirm, the Office of the Prosecutor, that in July 2002 we received a Rules of the Road file in relation to the events in the Dobrovoljovska Street in Sarajevo on 2 May 92. And that was, which included Jovan Divjak as one of the suspects. I can briefly describe the procedure, the Rules of the Road procedure, and remind you again, I think most of you know it. It was a procedure under the Rome Agreement of 18 February 96, which regulated the arrest and indictments of alleged perpetrators of war crimes by national authorities. Within the Rules of the Road procedure, the Office of the Prosecutor was tasked to provide an independent review of the allegations based on information provided by the authorities of Bosnia and Herzegovina. The OTP, the Office of the Prosecutor, would make a recommendation as to whether a prima facie case of serious violations of international humanitarian law within the jurisdiction of the tribunal existed. The review of the office we conducted was limited to that material contained in the file when it was sent, and for the purpose of determining whether the evidence was sufficient under international standards to justify the arrest or indictment of a suspect or continued detention of a prisoner. Now, the scheme ended in October 2004, and all of the Rules of the Road files we received from Bosnia were sent back to the State Prosecutor's Office in Sarajevo. So now going back to the specific case, we examined the file related to Mr. Jovan Divjak. Based on the information we received, at the time, the Office of the Prosecutor concluded that there was insufficient evidence for the prosecution of war crimes. And this information was communicated to the authorities in July 2003. The OTP did not conduct any further investigation in relation to this case.
So, to clarify, the file was sent to you by the Bosnian prosecutor?
Yeah.
And General Divjak was named as a potential suspect, yeah? And you concluded that there is no sufficient evidence to...
Yeah, it's important that we had a review function, so that was pursuant to the Rome Agreement, rules of the road. Whenever they wanted to proceed with an arrest for war crimes, crimes against humanity, genocide, the prosecutor from Bosnia, this case was from the Republika Srpska, would have to submit it to the Office of the Prosecutor in The Hague for review. We review the file and send it back.
So was it Republika Srpska prosecutor or Bosnia and Herzegovina?
Well, we informed the authorities of the Republika Srpska.
If I can add, there was no state prosecutor for war crimes at that time, in 2002.
Yeah, but just to clarify, so the file was sent to you by the prosecutor of...
Any prosecutor, local prosecutor at that time would have to submit a file to The Hague.
Who sent it actually to you?
It was a prosecutor from Bosnia. I cannot say who specifically, because I'm not going to go into the details, but like Nerma said, there was no federal or central state prosecutor. So it was from the Republika Srpska.
Yeah, okay. So it's from Republika Srpska. Okay.
Yeah. And so our recommendation was based on the information we received. And based on the information we received, we said there is insufficient evidence. Today, it's not for us to decide whether there is sufficient evidence or to make any further comment. We are not involved. And I think it's good for the facts, for the record, to get the facts straight of what our involvement was in this matter. And similarly, that was the same situation with the Ganic case. Yeah. If you want more information on the Rules of the Road program, we can post a link on with further information on that's on the website. Background information, how many files we reviewed, and we sent back. Yeah.
Any other questions?
I have a separate question concerning the Haradinaj case. I would ask you to clarify the state of the proceedings against the key witness Šefčet Kabashi, who refused to testify, and then he was indicted by the tribunal for contempt of court in 2007. Then he left The Hague, and again from U.S. Declined to testify. Mm-hmm. Now we heard the prosecutor in a recent status conference that he is still declining to testify. So I'm interested whether there is a warrant for Kabashi's arrest issued by the tribunal to the United States government, and basically where we are in this case.
Well, at this stage, regarding Šefčet Kabashi, I can confirm that the indictment that was raised in 2007 is still valid. It remains to be valid until the trial chamber decides otherwise or issues a decision to that effect. As you know, the practice of the tribunal has not been to issue public warrants of arrest in recent years. So I wouldn't be able to confirm anything to that effect at this stage, but I can reaffirm that the contempt of court indictment remains valid. Now, how the information provided by the prosecution in recent weeks is going to be dealt with will be up to the trial chamber to decide, and after hearing from the parties. But as you know, the case of retrial of Haradinaj at this point cannot be scheduled for commencement until the appeals chamber deals with the appeals of the defense regarding the scope of the indictment for retrial. So we will just have to wait and see how it develops in the coming weeks. Okay, no more questions? Thank you very much.